Hello, my name is Nicole Weber. I'm an immigration lawyer with Hurtubise Weber Law with offices in San Francisco and San Jose, California. Today I'd like to talk about obtaining a green card through marriage to a U.S. citizen. First, I'd like to note that immigration law is very complex, and it is important to consult with an immigration attorney before taking any action. So what is a green card? A green card gives the recipient the authority to reside and work in the United States indefinitely. It also allows the recipient to apply for citizenship after a certain period of time has passed and certain eligibility criteria have been met. Please see our video on the citizenship process for more information on this issue. Who is eligible to apply for a green card based on marriage to a U.S. citizen? There are 4 primary requirements for eligibility in this situation. First, you must be legally married to a U.S. citizen. This means that your marriage must be recognized as valid in the place where it was performed. Same-sex marriages will be recognized as valid as long as this criterion is met. Also, the sole purpose of your marriage must not be to evade the immigration laws. The officer who reviews your application will determine whether your marriage is bona fide by looking at evidence such as whether you and your spouse have been residing together, sharing finances, and spending a significant amount of time together. Second, your spouse must be willing and able to sponsor you in your application. This means that your spouse must either make enough money or have enough assets to meet the eligibility requirements for a sponsor. If this is not the case, another U.S. citizen or green card holder may serve as a joint or co-sponsor. Third, you must be admissible to the United States. This means that you must not be subject to any bars to admission. Please see our video on bars to admission and waivers to determine whether you may be subject to a bar, and if so, whether you may be able to apply for a waiver of that bar. Fourth, and finally, you must be eligible to adjust status here. Please see our video on adjustment of status to determine whether you may be eligible. What is the process for applying for a green card based on marriage to a U.S. citizen? Applying for a green card in this situation involves a 5-step process. First, it is important to meet with an immigration lawyer to be sure that you are eligible for the green card. Next, you and your attorney will complete the necessary paperwork and gather a lot of documents to prove your eligibility. You will then file your application with USCIS, the Immigration Department. They will schedule a time for you to be fingerprinted so that they may run a background check. They will then schedule a time for an interview for you and your spouse. At the interview, you and your spouse will be expected to answer basic questions about yourselves and your relationship. If your application is approved and you and your spouse have been married for less than 2 years, the green card will be conditional in nature. This means that it will expire after 2 years after the date it is issued unless you apply to have the conditions removed. At that time, you will need to show, in general, that you and your spouse are still married and residing together as a married couple. There are exceptions to this rule. If the conditions are removed, you will receive your permanent green card, which will then need to be renewed every 10 years. Thank you for watching, and please contact us if you have questions about your unique situation.